versus Crocker. The appearances are the same as prior to recess. The court has heard from and considered the pre-sentence investigation, the plea questionnaire, the state's argument, the statements from the victims and their families, both made in court and presented to the court, defense counsel's argument, as well as Ms. Crocker's allocution. And the English language has a boundless capacity for description. It's on days like this and in circumstances like those before the court that I wish that words could not really convey the horror of the acts before me. In crafting and preparing a sentence, the court must look at specific sentencing objectives known as the Gallian factors. There are 6 total factors. First, a sentence must recognize the gravity of the offense, must protect the public, must punish the defendant, must rehabilitate the defendant, deter others, and support victims and witnesses. The court here has focused on all 6 factors in preparing its sentence. In recognizing the gravity of the offense, the court sees and notes that the gravity is extreme. The defendant preyed on 4 separate victims on multiple occasions and with different ploys. In one instance, with regards to the victim, the court has identified as Zach. The defendant ambushed the victim, assaulted him in his sleep, and forcibly subjected him to sexual intercourse without his consent and against his protests. With regards to the victim identified as James, the defendant not only engaged in sexual assault of a child, she enticed him out of his house in the middle of the night to cross who knows and how much space without notifying his parents, essentially pulling him from his home, from the safety and sanctity and security of his home in the middle of the night. Beyond that, she engaged in what appears to be a campaign of intimidation and recrimination intended and focused on shaming or otherwise blaming James for the actions that she undertook and inflicted upon him. With regards to Chris and Sam, the defendant actively reached out to 2 children, made distinct and specific attempts to ingratiate herself into their lives, and then introduced and exposed them to harmful sexual material, and then attempted to solicit the same from them in return. Under the circumstances, the court finds those acts horrific and extreme, and the offenses accordingly so. Additionally, the court needs to craft a sentence that would protect the public. As just described, the court and the facts in this complaint identified 3, and by extension 4 victims, and what appears to be a course of conduct and a decision to solicit sexual intercourse and sexual contact from minors that only stopped because the victims showed incredible bravery and strength in reporting and facilitating law enforcement's investigation. In many cases, that bravery came at a personal cost to the victims. Not only did they face direct harms and the direct consequences of the acts inflicted and the pain and the trauma inflicted upon them by the defendant, but they faced ostracism, shame, and ridicule at school and in their social lives. In many cases, that ostracism and shame was not just the result of their peers, but the result of the defendant actively reaching out and attempting to shame, belittle, or demean, or otherwise blame the victims for the acts that she herself perpetuated. The next objective is that the court needs to impose a sentence that would punish the defendant. The court's already outlined its opinion and its belief as to the gravity of the offenses. In this instance, the severity and the extremity and the honestly, frankly, aggravated nature of the underlying crimes suggests and says to the court that there needs to be a sentence imposed with a distinct purpose of punishing the defendant. Furthermore, the next factor is the rehabilitation of the defendant. The court sees a de minimis need to focus on rehabilitation under these circumstances. The extreme nature of the sentence emphasizes, the extreme nature of the crimes emphasize the need that the court focus on protection, punishment, and deterrence, more than we focus on rehabilitation. The next objective is the goal of deterring others. In imposing a sentence, the court must prepare and believes in imposing a sentence that would reject any suggestion that the sex of the victims or the defendant attenuates the severity of the offenses in any capacity. As a society, the court recognizes that we do not tolerate persons who prey on children. Imposing a sentence that deters others and imposing a sentence that would deter others is a substantial purpose and objective of the court. Furthermore, the court, and finally, the court focuses on supporting victims and witnesses. This factor, this objective, is particularly heightened in the court's estimation. Children suffer life-shattering consequences as a result of the defendant's actions, as a result of the crimes committed. They've been transformed from relative innocence and abruptly and unexpectedly forced directly to confront adulthood. However, the court does want to say that it rejects the contention that the defendant's crimes have permanently damaged the victims. They are not the sum of their traumas, and they will not be the sum of their traumas or the harms that were imposed upon them by the defendant. The court believes and hopes that the victims still have and will have the opportunity to heal and to recover. In addition to the sentencing objectives, the court needs to focus on a number of sentencing factors. In this case, the court is focused on the gravity of the offense, including the nature of the crime, which the court has already outlined and described in detail. But furthermore, the court needs to examine the vicious or aggravated nature of the underlying conduct. Here, the court sees that as substantial. As described with regards to Zach, the defendant ambushed and sexually assaulted a sleeping boy. She enticed another out of his home in the middle of the night to enter a public, strange area in order to sexually assault him. She then enlisted 2 other children to harass and intimidate that victim. The descriptions in the pre-sentence investigation show a repeated and almost boundless capacity of the defendant to refuse to accept a simple no as an answer when the victims attempted to block her communications on Snapchat or to ignore her or to otherwise separate themselves from her. As described in the PSI, the defendant continued. She didn't relent. She did not let up. She would continue finding ways to reach out to them, to ignore their wishes, and to insinuate herself back into their lives and into their communications. That further aggravates and exacerbates the nature of the defendant's conduct. Moreover, she would guilt, blame, or deflect responsibility for her actions onto the defendants. The court has reviewed text messages and messages that in which, after these assaults occurred, the defendant would blame or otherwise assign responsibility for her assaults, her actions, her crimes onto boys who were 12, 13, 14, were too young and unable to be responsible for the actions. And that's not even withstanding the facts, which themselves established that the victims did not have an active role in the underlying actions. In reviewing the defendant's character, the court does note, as a point in the defendant's favor, that she does not have a history of prior criminal offenses. However, the history of undesirable behavior patterns is substantial, as the court has repeatedly and at length outlined. The behavior patterns perpetuated by the defendant reflect a continued desire and intention and goal of enticing and using children for her own sexual gratification. She sought out children, she used children, and she took advantage of children. She was an active participant. She was the driver of those decisions and of those actions, and she did it repeatedly and consistently. The court also focuses on the defendant's personality and demeanor, as well as her culpability, remorse, repentance, and cooperation. Here, the court does note with approval that the defendant in open court today, during her allocution, stated that she took full responsibility for her actions and their consequences. However, the court has to measure that statement of accountability against the additional statements made by the defendant, as well as the statements made in the pre-sentence investigation. Specifically, in multiple occasions throughout the PSI, the defendant cast herself as the victim and the victims as perpetrators, shifting blame and assigning responsibility for the crimes that occurred not on herself, but to the children that are going to suffer harm and trauma as a result of her actions. In the court's estimation, in the court's view, that is not taking responsibility, that is shifting blame. In fact, during her allocution, the court heard the defendant say, "What happened wasn't me," or that this is difficult for me. And moreover, the defendant's allocution focused less on the harm suffered by the victims and more about alleviating the potential impacts or consequences that she and her family would suffer as a result of a conviction and sentence. Moreover, the court wants to draw specific attention to a portion of the pre-sentence investigation that gave, it's hard to describe how effective this particular portion is. The portion of the pre-sentence investigation begins with statements in which the defendant characterizes, at the end of the day, the victims were inappropriate with her. She says she should have nipped it in the bud and she never should have allowed the inappropriateness in the first place. She agrees that this was traumatic for the victims. But then she says that she hasn't gotten over what she has suffered and she hopes that they can heal better than she did. The court, as it reads that paragraph, sees an implication from the defendant that the actions, that the harm that she caused to the victims, in fact, harmed her, and that she hopes the victims are better able to heal than she will be, which is, in the court's estimation and view, a wholly inappropriate and frankly horrific reaction to causing trauma and harm to children, is to turn about and hope that those children are better able to heal from the trauma that she suffered as a result of what was imposed, what she did to the boys themselves. The court finally focuses on the defendant's age, education, background. Here, the court notes that the defendant's age and education are generally unremarkable, and her background is generally unremarkable except for the history of trauma, abuse, and substance dependency. However, while those may explain the defendant's conduct, it does not and cannot and can never excuse it. It's okay and it's all right to feel pain, to be confused, and to suffer chaotic emotions because of abuse and trauma. But it's not okay to turn about and to flip out and to inflict those harms on others because of those emotions. Finally, the court does note the defendant's history of employment in child care and child care adjacent fields, specifically the fact that the defendant was, at the time of these offenses, employed at Riverside Middle School, where she would have had daily and regular interaction with, if not these children, children in the same or similar age range. This is not someone who would be surprised by the relative maturity or immaturity of 12, 13, and 14-year-old boys. This is what she lived, this is what she experienced, this is what she knew daily. Once again, as final factors to consider, the court looks at the defendant's rehabilitation needs, which the court has already emphasized as a de minimis concern in imposing this sentence. The court finally wants to focus on the need to protect the public and to acknowledge the rights of the public. And in this, the court turns to the victim statements prepared and submitted by both the victims and members of the community at large, which repeatedly and specifically emphasize the shattered bonds of trust that have resulted as a product of the crimes committed by the defendant. What was formerly a tight-knit and potentially trusting community now has difficulty letting children out of their sight, difficulty trusting their friends, their neighbors, their community members, understanding or appreciating, strike that, fearing that children left out of sight or out of sight are potentially subject to harm. That is a devastating consequence that extends beyond just the immediate harm suffered by the victims and their families themselves, but causes scars that will ripple through the community that she's affected. The court, in imposing a sentence, must impose a sentence that calls for the minimum amount of custody or confinement consistent with those sentencing objectives and factors. In doing so, the court should consider probation as the first alternative, unless it finds that confinement is necessary to protect the public. The defendant requires correctional treatment that would be best provided in confinement, or probation would unduly depreciate the seriousness of the underlying offenses. The court specifically finds that all three factors apply here and that probation would not be an appropriate sentence. Accordingly, the court hereby sentences the defendant as follows. First, the court will not impose or order restitution payable to the victims. There are two specific cases in Wisconsin that address the argument for restitution prospectively for future costs or therapy, as well as the generalized psychological, emotional harm. In both instances, controlling Wisconsin law says that the court may not impose restitution for indeterminate emotional or psychological harms or for the respective costs of treatment or therapy. However, the court will refer this matter to restitution, to the court commissioner, and shall direct and instruct and, more importantly, permit the victims to submit claims for costs of existing treatment as restitution, or other claims of restitution that will be subject to restitution in the ordinary course of 973.20 and a referral to the court commissioner. The parties are, of course, free to stipulate to restitution as well upon submission of invoices or expenses by the victims. As to the charges themselves, the court has grouped the charges into 3 categories, specifically by the victims affected by each charge. With regards to the counts affecting the victim identified as James, those are counts 3, 8, 9, 10, and 12. As to count 3, that is the child sexual enticement, the court imposes a sentence of 40 years in the Wisconsin State prison system, bifurcated into a 25-year term of initial confinement and a 15-year term of extended supervision.
I don't mean to interrupt, but you said child enticement. It's child sexual exploitation.
Pardon me, the court had it abbreviated as CSE, so child sexual exploitation. Again, the sentence is 40 years in the Wisconsin State prison system, a 25-year term of initial confinement, a 15-year term of extended supervision. As to count 8, use of electronics to facilitate a child sex crime, the court also imposes a sentence of 40 years in the Wisconsin State prison system, bifurcated into a 25-year term of initial supervision and a 15-year term of extended supervision. And again, that is 25 years of initial confinement, 15 years of extended supervision. As to count 9, enticement, the court imposes a 17.5-year term in the Wisconsin State prison system, bifurcated into a 10-year term of initial confinement and a 7.5-year term of extended supervision.
Is that count 9?
That's count 9.
I think its breakdown is 15, 10. 10 for extended is the maximum.
Correct, and the court imposed 17.5,
Okay.
10, 7.5.
Okay, thank you.
As to count 10, the court imposes a 40-year term in the Wisconsin State prison system, bifurcated into a term of 25 years of initial confinement and 15 years of extended supervision. As to count 12, witness intimidation, the court imposes a 6-year term in the Wisconsin State prison system, bifurcated into a term of 3 years of initial confinement and 3 years of extended supervision. Counts 3, 8, 9, 10, and 12 will be concurrent to each other. As to count 1, which addresses the victim known as Zach, the court imposes a sentence of 40 years, and this is the first-degree child sexual assault. The court imposes a 40-year term in the Wisconsin State prison system, bifurcated into a 25-year term of initial confinement and a 15-year term of extended supervision. That sentence will be consecutive to the sentence imposed in counts 3, 8, 9, 10, and 12. Finally, as to count 4, intimate exposure to a child, which addresses the victim identified as Chris, the court imposes a sentence of 3.5 years in the Wisconsin State prison system, bifurcated into a term of 1.5 years of initial confinement and 2 years of extended supervision. This sentence will be consecutive to the sentence in count 1, which again is consecutive to the concurrent sentences imposed in counts 3, 8, 9, 10, and 12. As for the conditions of extended supervision, Ms. Crocker, you are to obey the rules and regulations of your supervision agent. You are to pay all supervision fees. You are not to possess or consume alcoholic beverages, and you are not to have alcoholic beverages within your residence. You are not to possess or consume controlled substances except by prescription, and then only in the prescribed amounts. You are not to be present in any taverns or premises licensed to sell intoxicating beverages except for restaurants or grocery stores. You are to submit voluntarily to random tests of blood, breath, and urine. You are to participate in counseling as deemed appropriate by your agent. You are also to follow through with any recommended treatment suggested by your agent. You are to actively search for employment, be employed, or be attending an educational institution or vocational program during your extended supervision. You are to submit a DNA sample. You are to pay any DNA surcharge associated. You are to submit to lifetime registration on the Wisconsin Sex Offender Registry. You are not to reside with any person or in any place where children reside. You are not to have any contact with the victims, with their families, or with the individuals identified as BS and SS. They are minors in the criminal complaint and the pre-sentence investigation. You are to have no contact with children. You are to have no employment in a context that would put you in regular contact with children. You are only to have supervised contact with your children. You are not to have any social media accounts or to access social media. You are to have no recording devices. You are not to access any pornography. And you are not to possess any weapons, including firearms. Madam Clerk, are there any additional conditions that the court needs to address? The court also specifically finds that the defendant is not eligible for the challenge incarceration or earned release programs. Madam Clerk, are there any other conditions or issues in the judgment the court needs to address?
Any unrelated children in her residence?
No unrelated.
And then will the court schedule the restitution hearing, and that's to be within 60 days?
Correct. We will set this for a restitution hearing within, and we'll put it out as long as possible.
March 16th at 1:15.
And that will be before, most likely, Commissioner Potter State.
Okay.
You said March 16th, what time?
1:15.
I can do that.
Ms. Delgado, do you have anything additional to add to the record?
No.
Mr. Schwartz, same question.
Yes, sir, so I may have missed it. Did the court order credit?
Thank you for the final reminder. Ms. Crocker will receive credit for the 490.
464.
96.
496.
Sorry.
Court transposed 496 days of pre-sentence incarceration.
And then one other thing, Your Honor, the court ordered no unsupervised contact with her children. Would the court be willing to end that when they turn 18?
Yes, that condition will terminate upon the children reaching the age of majority.
Thank you.
Anything final, Mr. Schwartz?
I don't believe so.
Then we're all set here. Thank you all for your time, and take care.
Thank you.
Yes, that was my guess.
Well, she's already served. So it should be 85.
Yeah, how old is she now?
I just lost it. But I think I came up with 86. Mid-80s. Underneath your back, just double that.
We've built a house before.